Good morning. Good morning. My name is Kristen Antolini. I'm an assistant prosecuting attorney in Monongalia County. Thank you so much for the opportunity to share. I love to talk about my favorite subject, which is child welfare. And I see several folks that I know from our child welfare community online, and I apologize because to them, my presentation is things that they live and breathe every day. But I'm so happy to be joining your community this morning to be sharing. I would love for people to ask questions as we go along, so feel free to unmute and just interrupt me if you have anything that you would like to ask me during the presentation, or you can also put it in the chat. And thank you again for this opportunity. A little bit about me this morning. Although my current job is as an assistant prosecutor, in my previous life, I was a guardian ad litem for many years in the child welfare system. A guardian ad litem is an attorney that represents a child who is currently in an abuse and neglect case in West Virginia. And my heart will always be in that representation of children, even though now, currently, as the prosecutor, I represent the Department of Human Services. But serving children, looking out for children, and the best interests of children, I know is what everyone strives for within our community, and that's certainly where my heart is. In addition to being a guardian ad litem, just a fun fact about me. Sometimes child welfare leads us to many different avenues and opportunities and experiences in life. One of my most fun experiences was I was featured on a documentary called Recovery Boys that's on Netflix, and it is about Virginia, out at the Center Jacobs Ladder in Preston County, which I'm sure many of you are familiar with. But like everyone in child welfare, we are a community and we get to do some really neat things sometimes. And being in Recovery Boys was something that I always really look back at with thinking, wow, that was really cool for an opportunity. Um, I was about what the court process looks like for child welfare and some of the challenges that we may face in the child welfare system, kind of from an attorney perspective, so from a guardian ad litem perspective, and from representing the department as a prosecutor perspective. So just to kind of start our conversation today, just a little bit of a snapshot. Who are we focused on here? Who are we talking about? And at its core, we're talking about children who are in the care, custody, and control of the Department of Human Services. We used to call it DHH, I know, by the legislature. And so now we're the Department of Human Services, and underneath the Department of Human Services is Child Protective Services. Their name stayed the same. And currently, at least this is the most current statistics from the department's child welfare dashboard that's online. There were 5,897 children in the department's custody in West Virginia, with 332 of those children in out-of-state child placements. Thankfully, through the work of many people statewide, our numbers in placing children out of state have lowered. And you can see all of the different places where children that are in department custody are placed. They may be placed in therapeutic foster care, a kinship relative home, our biggest number of children, over 3,000, group residential care, in-state psychiatric and medical hospital, transitional living, um, emergency shelters, and a few other places as well. In addition to all of the children who are in state's custody, the department also touches children who may still be in their parent rental custody, whether it's just through providing services or whether through an open court case where the department have not taken custody. So even though we have almost 6,000 children in care, the department is charged with making sure that children are safe, many more than just 6,000, because we also have many children that the department is just providing services for that still remain in their home with their parents. But how do children who are in foster care or in department custody come into care? As many of you know, a lot of that first step is someone calls into our hotline in centralized intake. And I'm sure most of the people on this call have had to make a call into centralized intake. And our statute requires that any medical, dental, and mental health professional calls into centralized intake. Back in the old days, we used to kind of call county by county, but several years ago, the department made a very new, efficient system where there's just one telephone number where everybody calls into. And that number is right there on the screen, 1-800-352-6513. And it's operational 24 hours a day for any reports of suspected child abuse. And something that I just kind of wanted to highlight for those of you who may be mandatory reporters, just remember that if a child discloses to you, let's say in an emergency room, at a child advocacy center, in any kind of setting where you're a mandatory reporter, if there is a disclosure of serious physical abuse, sexual assault, or if you believe that one of those to be the case, you are also required to call the West Virginia State Police and any other law enforcement agency that would have jurisdiction to investigate those. So it's not just enough just to call the mandatory, it's not enough just to call the centralized intake line. And if you do need to call in to centralized intake to make a referral for abuse and neglect, this is just a little desk guide about what information that you need when you call in. So you need to have the county of incident, the last name of the caregivers or the parents, the address of the family, if you have directions to their home, phone numbers, whether there are any hazards or dangers to a worker. As I know everybody knows, being a child protective services worker is a pretty dangerous job at times. And so we want to make sure that we've let the department know if there's any potential hazards to the workers. We'd like to know the name of adults in the home, their date of birth and age of the adults and the children, detailed information about abuse or neglect and location of the children and location of the parents. Just a practical tip, you can email photos and documents into centralized intake. You can ask them for the email address when you're on the phone with them, and that really helps the department kind of sort out what should be done next. After you make that referral, at the end, they'll ask for your reporter information of your referral was. And the fact that you make a referral is always confidential. That information is never provided to a family or to a judge or to anyone else. And why do our children come into care? It can be just for a variety of reasons. Our West Virginia State Code allows for a wide variety of to come in as cases with the circuit court system. So, of course, we have the ones that you may think about: sexual abuse, non-accidental trauma, nutritional deprivation, abandonment, inadequate treatment of serious illness or disease, substantial emotional injury, substance abuse. And then our code allows for any other condition that threatens the health, life, or safety in the home. So it's really a catch-all. So whatever may be causing a danger to the children in the home can really come in as an abuse and neglect case. And so, what happens next when a report is made decentralized intake? Several things screened out. When it comes into centralized intake, they're going to take a close look at it to see whether the report arises use and neglect. And if it's screened out, our local office generally never sees that unless they go back specifically to look for it. If it's screened in, it's going to be assigned to a local office for investigation by an intake worker. Each child protective kind of has two parts to it. It has an intake, so that's like our investigative workers, and it has an ongoing, and those are the workers that are responsible for the day-to-day management of cases that have already kind of been through the system for a while. And if it's screened in and that worker will then kind of make a safety assessment, do an investigation, and see if there is abuse involvement. They can also say that it doesn't they can say that no, there's no danger here. We're going to close it out. Or they can say, yes, I think that I have some concerns here and we need to look at this further. At that point, the department connection plan, which is a 7-day voluntary plan with the parents that has some instructions for the parents about what's going to happen. So it could be that the parents have to leave the home, or the children are going to leave the home, or maybe there's going to be a forensic interview done. And those are only good for 7 days, and they can be revoked by the parent at any time. The department may decide that the child is in imminent danger of use or neglect, and it's necessary to take emergency custody. The department, they can either turn on scene if it's really emergent, or they can go and get an order first before taking the children. But either way, the department worker will appear in front of a judge and request a ratification to ask for emergency custody, and that's good for two, has to be filed. The department also can opt to try to do some safety plans. So you can do an in-home safety plan so the children remain in the home and services are placed within the home to help assure safety, maybe something like counseling or drug screening or other community services. You can also have an out-of-home safety plan for 90 days where maybe the children are not going to be in the home, but the department's going to recommend some services for the parents and work with them without the necessity of a court case. In all instances, the department is always working towards whatever the least restrictive alternative is in order to be least restrictive. And sometimes these are just judgment issues, and we do our best at all time to opt for the least restrictive alternative and try to avoid taking children out of the home. But sometimes we just can't based on the safety concerns present within the home. And who is kind of part of the abuse and neglect process? So if the department opts to just have an in-home safety plan or an out-of-home safety plan, then the only folks in West Virginia that are going to be part of that process are going to be the child protective services worker, the parents, the children, and then whatever providers are working with the family, whether that is a counselor, maybe the day report center, maybe it's going to be the Coke Clinic staff at WVU Medicine, or maybe it's going to be, peer recovery staff over at Valley Healthcare. Whatever has decided that a case is necessary, and a court case can be opened whether or not the children are placed in department custody. So sometimes we'll have cases, we call them general petitions, where the children are not placed in department custody, they remain in parental custody, but we arise to a level of we need to ensure that their safety and we need court oversight for that. If we remove children from the home due to an imminent danger to these children, then that's always going to result in a court case. And we call those imminent danger petitions that are being filed. It is a general petition or imminent danger. So anytime there is a court process involved, we have a lot of people involved in that process. It's the children's attorney that we call a guardian ad litem. It is the parents or the caregivers. We call those adult respondents in our cases. And you can be an adult respondent whether or not you're a biological parent. So it's both biological parents and anyone who provides caregiving to the children. We can have interested parties. So for example, if we have one parent who maybe committed domestic violence in the presence of the children and the other parent is being protective, the parent who committed the domestic violence is going to be an adult respondent, and the parent who was protective is going to be that interested party. Whether you're an adult respondent or an interested party in West Virginia, everyone is entitled to an attorney. So the court is required to appoint children and any adults participating in the case an attorney. That's not the case in every state. So we are actually very lucky here in West Virginia that the system provides that because it's important for everyone to have their rights protected and to understand the process and to kind of have someone there to help facilitate everybody working along because as upset when Child Protective Services is involved in their lives. And we're lucky in West Virginia that attorneys are appointed for everyone to help them understand, why Child Protective Services is involved, why the court system is involved, and kind of explaining the process to them. Of course, other folks in the abuse and neglect case include child protective service workers, the prosecuting attorney. By West Virginia Code, statutory counsel for the department is the prosecuting attorney's office. So, just like I said earlier, my job as an assistant prosecuting attorney is to represent the Department of Human Services. So, I represent Child Protective Services in each case, and that is standard in all 55 of our counties. We'll also have CASA for kids, a court-appointed special advocate for children as part of the process. We might also have kinship foster parents, regular foster parents. We might have a child advocacy center designee if a child received services from the child. Also have school officials. We might have a managed care case coordinator. Here locally in our cases, we're very fortunate as we have folks from WVU Medicine part of our MDT process. And by statute, they're part. We might have domestic violence services providers, and then any other person or agency providing services to the family. Just kind of a rough outline of what are the stages of an abuse and neglect process. We kind of have your petitions. So we're going to have a preliminary hearing, which is essentially just did the department have the right to come and place your children in department custody? We'll then have an adjudication hearing, which is whether or not abuse and neglect occurred. These are civil proceedings. And so an adjudication hearing is sort of like a trial, did something happen, except it's just before the judge, but that's how we kind of try to frame it for folks so they can have a better understanding of it. The disposition rights, or are you going to be granted an improvement period in order to work through the case and have a successful reunification? And then the last stage is permanency planning. If the department's filed a petition that doesn't involve removing the kids out of parental custody or caregiver custody, then there's no preliminary hearing. We go right to the adjudication hearing. On your screen is a more detailed diagram of all of the steps of an abuse and neglect case. And frankly, I think abuse and neglect can kind of seem like a mystery to people who aren't used to it day in and day out because we have our own set of verbiage. We have our own way kind of doing things. And you'll often hear attorneys or child protective services workers kind of spout out words that you may not have heard before, if you're a provider or a parent in a case. And so we're always grateful for the opportunity to show everybody what the process of abuse and neglect looks like because it has its own language. And so on the screen is a little more detail about really the flow of what happens. Our statutes have very, very specific deadlines for when everything has to happen in an abuse and neglect case because as you know, children cannot wait for permanency. They cannot wait for all the adults to have how much ever time is needed to kind of figure out their lives. And so we have very definitive deadlines in abuse and neglect cases that we are required to follow by West Virginia Code. Everything that kind of outlines what we're supposed to do in abuse and neglect cases is found in Chapter 49 of the West Virginia Code, if you're ever interested in reading about it. It's also found in the West Virginia Rules of Procedure for abuse and neglect proceedings. Our Supreme Court also puts out a book called the Bench Book for Abuse and Neglect Proceedings, which is online. It's a free resource, and it goes into a little more detail all of the relevant case law that we get from the Supreme Court of Appeals of West Virginia and those rules of procedure for abuse and neglect proceeding. And that's what we use collectively to kind of guide our process through the proceedings. The department also promulgates their own policy about how things are going to flow and how the department will handle things or should handle things. So it's also helpful to kind of read up on the department's policy, which oftentimes is also in line to kind of get a better understanding of the process. As far as the court process, as a prosecutor, what I do is I prepare that petition on behalf of the department that's going to start the process. And like I said, if there's a child in imminent danger, we will do an emergency removal hearing very early on. We call it a preliminary hearing within 10 days of the filing of the petition to determine whether or not the department had the right to place children in the care, custody, and control of the department. Again, if it's not an emergency petition, if it's a general petition, we don't have that preliminary hearing. In lieu of an adjudicatory hearing, we can grant folks what's called a pre-adjudicatory improvement period of 3 months. And instead of being adjudicated for abuse and neglect, they can go through an improvement period for 3 months to participate in services and to show the department and the court that have made the changes necessary in order to keep their child safe. It's not something that's done very often because 3 months is not a lot of time when you're talking about it's like substance abuse or domestic violence, but it is a tool that we have in our toolbox to kind of handle these cases. If a parent successfully completes the pre-adjudicatory, then it is dismissed at the end of those 90 days. If we have an adjudication hearing and the parent is found to be adjudicated as an abusive and neglectful parent, the court has several different ways it can go from there. It can grant period, and that's usually for 6 months, although it can be for less time. And that's subject to an extension of another 3 months. So a total of 9 months in order for the parents to participate in services. The department will offer parents services in the form of drug screening, in the form of parenting, in the form of adult life skills. However, we greatly rely and mental health and domestic violence services, just across the board, and helping us craft on a case by case basis the best services for a family. And this is ongoing discussion and it's always evolving. And so, anyone on here who is providing services for families, and maybe you don't have, currently a strong relationship, maybe with your local child protective services organization or your local prosecutor's office. I really encourage you to reach out because abuse and neglect and child welfare is all about collaboration and utilizing are so thrilled to be here with you today because to be effective in child welfare, we need everyone at the table that can help us make these families stronger, which in turn makes our community stronger. And so, really, at its core, the purpose of that post adjudicatory improvement period is, in fact, to provide services for families that will make them stronger and will hopefully take care of the safety issues present in the home. If a parent successfully completes that post adjudicatory improvement period, then their case at that point can be dismissed, or if they need some additional time, the court can grant them what's called a post-dispositional improvement period. And it's the same kind of setup. It can be initially for up to 6 months and then another 3 month extension. And if they complete that, then the case will be dismissed and rights return. Sadly, a lot of times folks aren't able to complete all the requirements that the department sets forth. And in those instances, the court's options at that point either is to suspend parental rights with what we call a disposition 5 or to terminate parental rights with what we call a disposition 6. There are a few other options. We can place children back into the care with some pretty tight restrictions or what can and can't be done or requirements about what should be done with therapy or other things. But for the most part, we their parents, we suspend parental rights, or we terminate parental rights. If there's a termination of parental rights, we do our best to achieve permanency as quickly as possible, either through a guardianship or through an adoption. Unfortunately, we have children that are not able to maybe achieve permanency for as quickly as we would like, because maybe they need, a little extra help. They may need, a psych placement, a residential placement. They just may have some special needs that require some additional time and assistance before permanency can be achieved. If you're interested in kind of our lingo and a little bit more about the things that I was just talking about, on your screen is a list of where all of that language comes from, where that procedure comes from in the code, and where those definitions are of abuse and neglect and imminent danger and how they kind of cooperate together if you're interested in a little more reading on it. Every county in West Virginia also gets together usually once a month, maybe a little bit less, to kind of have what we call MDIT, a multidisciplinary investigative team. So sometimes, these cases just simply come through a referral through centralized intake, and the department kind of takes care of it from there. Other times, cases might come through centralized intake, and then we want to bring it to the table to discuss with all of our providers because, as I said, abuse and neglect and so every month all of these entities get together to talk about their cases. The prosecuting attorney, child protective services, local law enforcement, child advocacy center, healthcare providers, mental health care providers, educators, and domestic violence service providers. Here in Montague County, we're extremely lucky because sometimes we've had up to 3 folks, sometimes more, from WVU Medicine at our meetings. We'll have Dr. Amy Gavril and her nurse practitioner assistant, and Meredith Pheasants, who, as you all know, is a scene nurse. And so we're very fortunate in Montague County that we can have all of the support from all of these agencies. I know that every county is not quite as lucky as we are, but in an ideal world, these are all the folks that come together from our communities to work on that investigative team to make sure that children are safe and that the proper investigations are being done. I know I just have a few more minutes left. I just wanted to talk use of forensic interviews of children and kind of what those are. So for the most part, when we have an abuse and neglect case, generally speaking, we don't bring children into the courtroom to have them testify about the trauma that's occurred to them. We use other means. So we may use the child protective service worker to testify. We may use, who saw them in the emergency room to testify. We may use their counselor. We can also use what's called a forensic interview. And that's where a child goes to one of our 21 child advocacy centers across the state of West Virginia, and they meet with a specialist who trained in forensic interviewing, and that is recorded. And the child kind of tells the interviewer what's happened to them. And we use those as part of our abuse and neglect process in lieu of actually having a child come to testify. The normal phases of a forensic interview are threefold. We have kind of a rapport building phase, so the child gets to know the interviewer and vice versa. We have a substantive phase where the interviewer seeks to get all the information related to the alleged abuse. And then we have a closure phase where the interviewer kind of addresses the child's emotional needs, answers the child's questions, usually wraps up with some kind of body safety or other safety lesson at the end of the interview. If we have little tiny children, they may not be able to do that in just one session like our older kids. And so sometimes you might hear about an EFI, an extended forensic interview, and that's where little kids use to do the same process that a bigger kid might do in just one interview. Here's a little map of all of our child advocacy centers that do these interviews for us across state. And the numbers in West Virginia are just substantial. Last year alone, in West Virginia, there were 4,702 forensic interviews. And in these centers, they also usually provide therapy and sometimes a medical examination. And last year they had 881 children that they served for therapy and 317 children that they served for medical examinations with. We just have pretty significant numbers in West Virginia. Um, if you're working in a hospital setting, I just kind of wanted to go over who can see a child in the hospital, and this is also true for who can see a child at a school. So if a child is in department's custody and they happen to be a patient at the hospital, the folks that can come see them are child protective services workers, the child's attorney, their guardian ad litem, their assigned CASA for kids, and an individual designated by child protected hospital setting or a school setting, that you make sure that you get the proper identification or the proper order. So child protective services workers will have an official ID. It kind of looks like a driver's license, in order to access the child. The guardian ad litem and CASA for kids, and you'll see at the top of that order there'll even be like a little code at the top that can be verified to make sure that that's a good order. You can always call the prosecuting attorney's office or even the judge's office or your local CPS office if you just want to validate that that person does in fact, have an accurate order. They are who they say they are, and they can have access to our children who are in care. And a question that we sometimes get is if a child's in department's custody, let's say they're in the hospital, who can make decisions for them? And typically it's just child protective services. Just to kind of close, I wanted to share a couple of books that I really like if you're working with kids. I think that I found these helpful when working with kids to try to kind of explain the things that we deal with day in and day out. So if we happen to have a kid that does have to testify in court, which normally does not occur in a child abuse and neglect case, but it could occur in a companion criminal case, like a Monty's Day in Court is a great little book. And it really walks through to help a child understand what to expect when they have to testify in court. We have Annie's Appalachian Adventure. This was written by a former school teacher in West Virginia, and it talks about a little girl whose mom is in substance abuse treatment, and she's kind of exploring how that looks and what that looks like for her and her book, A Grand Family for Sullivan. It talks about little Sullivan living with grandparents, which, as you know, is a major good for helping kids kind of understand that. And I also like this book, Timby talks about addiction. If you ever order Timby, Timby also comes with a little stuffed animal, which just kind of helps in explaining how children can cope with a parent. It's like the Sesame Street in Communities website. They like really touch upon some very significant issues that are sometimes hard to talk about with kids or sometimes maybe even families. I've also used this to kind of listen to the language that they use to or even parents about tough issues such as incarceration, domestic violence, and substance abuse. And this website has just some great resources. I like this one about substance abuse, Carly's 7 C's. Just to when you're talking with a child, just to kind of color with them, and go over with them that they are not the problem. They can't control it, they can't cure it, but they can take healthy choices, and of course we all can celebrate them. So I think that those are some good resources that I've found helpful. If anybody has any questions for me, I would love to chat with you, and I appreciate the opportunity to be here.